The following program was produced by an independent community producer. The opinions expressed do not necessarily reflect those of the QATV staff or board of directors. QATV, in compliance with FCC regulations, is prohibited from exercising control over the content of independent, member-produced public access programming.
Oh, no. Song at the end. Hi, welcome to the show, Constitution, then and now. As I said last week, I was gonna have some guests on this week, and they showed up. Al Shurtleff, who's been here before, John Birch Society, and Dan McGonigle, an author, and also a member of the John Birch Society, correct?
Yes.
Okay. Al, why don't you start off by telling us what you'd like to talk about today?
Well, the focus of today's
'Cause
program
I
is...
know you're gonna be doing the same thing tonight too, right?
Right, tonight at your club, the Four River Club. Yeah, the topic of today's show would be the Article 5 under the U.S. Constitution, the dangers of an Article 5 convention. And let me start off by reading the Constitution under Article 5, and I think it's also going to be up on the screen. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislators of 2/3 of the several states. And that's the part we're concerned with, that part with the, shall call a convention for the purpose for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which now be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of equal suffrage in the Senate. And that part, that last part, came to pass when in 1807 Congress passed a law that forbade the importation of slaves. And it went on the books in 1808. So they did need, now, so the two ways to amend the Constitution, as I just said, is either when 2/3 of the U.S. House and Senate decide upon an amendment, and then it goes to the states. And that was the only way under our Constitution that we've ever amended the Constitution. And in 200 plus years, we've only done it, it's only 27 amendments, and the first 10, of course, were all done at the same time, 1791. So there's only been, in 2 amendments, one was to repeal another, prohibition, and the 21st. There's a couple of housekeeping amendments dealing with when the House will convene, January the 20th Amendment, January 3rd, and when the President will take his oath. It used to be in April, now it's in January.
Right.
So they're not fundamental differences here. And one dealt with the voting age, voting for women, the 19th, and the voting age, the 26th, I think. And the last amendment was very interesting, that dealt with pay raises. That was one of the original amendments proposed in 1789, when it would have been the First Amendment had it been passed, or First or Second Amendment, that dealt with pay raises, that a pay raise cannot go into effect. I can't raise my pay until the next session.
Right.
So that kind of, kept, and that finally passed after 25 or 30 years floating around state houses. So, presently, there's been a renewed effort for this thing, we refer to it as a con, as you see the banner, or an Article 5. And a lot of people pushing this are telling the legislatures that don't worry about any amendments that may seem to be unreasonable. It still takes 3/4 of the state legislatures. Well, maybe. The other way is that Congress can change the mode of ratification. Now, they did that when it came to the 21st Amendment. The 21st Amendment repealed the 18th, prohibition. And I'm not here discussing whether we should have or should not have, but they thought there would be a lot of dry states. There would be at least 15 to 20 dry states that would probably not go along with it. So they decided to have ratifying committees, or the word convention as they use. So the states didn't have, the state legislators never voted on it, you see. Now, we've had one federal convention in our nation's history, but the first constitutional convention was a state convention here in Massachusetts in 1779, 1780, when they drew up the Massachusetts Constitution. But we're not talking about a state, we're talking about a federal constitution. And under the Articles of Confederation, when states amended that document, you had to have unanimous. Every state had all 13 states at that time. So there was a convention, and the delegates decided to, some people use the term exceed their mandate, and some of the resolutions from the states gave them basically a blank check, do what you need to do. And that actually even reinforces our contention that in modern day Article 5 convention can, when they use the word runaway, and I use the word controlled runaway. It's not that it's going to be a bunch of people just doing all kinds of crazy things, it's people have a plan, you know. So that's a sovereign body. That body is more, for that kind, this is the body that created the Constitution, you see. So the states are the ones that create, so it's representing the states. So they can possibly change the mode of ratification. There's no guarantee they won't. So let me give a little history of the Article 5 movement in the country. The Constitution was ratified, you know the dates probably, you know, I think it was New Hampshire that triggered, okay, now it was the 9th state, I think it was.
Rhode Island came in struggling.
And Rhode Island was the 13th, it became the law of the land.
Yeah.
There were 2 calls for an Article 5 within the first couple of years. The first 100 years of the Constitution, every call was for what we call just a general convention. There was no specific reason cited by those applications. Because the bottom line is, the Constitution that I just read says that states will propose resolutions for an Article 5, to propose amendments, plural. So but for the first 100 years, you had issues like slavery. You had some strong issues. In fact, Abraham Lincoln supported an Article 5 for the purpose of abolishing slavery. But that would have still been an open forum, and they knew that. It wasn't until this populist movement took hold in this country, in the 1890s and early part of the last century, where they wanted to do away with the they wanted to have the direct election of senators. And that would mean that the senators prior to the 17th Amendment were chosen by the state legislatures. So what the states did, when they agreed to that amendment, they lost a lot of their power. See, a senator was basically an ambassador. Those 2 senators chosen by the legislatures would sit in, and before the income tax, they're the ones that brought the bill home. So they were very reluctant to vote for all this largesse. The members of the House get away with it. Oh, sure, we'll promise you the world. And when the states had to pay the bill before the income tax, and the tariffs, of course, paid a lot of that as well, but they said, well, Massachusetts, we have to prorate everything, and guess what, our bill may be X amount of dollars, and it's up to the states to raise that money to pay the taxes, you see. So the senators were very reluctant to pass a lot of bills that were unconstitutional. But when the 17th Amendment was passed, we lost that. But what happened was a lot of states had applications for a convention, Article 5 convention, with the purpose of having the election of senators. And we came about two states short of the needed 34. Oh, actually, it wasn't 34 at the time. It was less because you had a few states that, and joined the union since then. You had Arizona and of course Hawaii. And so whatever the state was, we were 2 states away from the 3/4. So what happened, and some argue that they had enough calls, but Congress passed the amendment anyway, and it went on to the states, it was ratified. So that wasn't necessary. And some of those calls are still in the books, you see. Anyway, so over the years there have been a number, there was resolutions, there's been over 600 calls for Concom. And some of them are included. There's been calls to change our Constitution to have a world government. Believe it or not, that's about it. And Florida was a state 3 times called for that, right? I wonder if it was because of Claude Pepper, he was an internationalist, maybe it was his influence, I don't know. States wanted to repeal certain other amendments. They had some states calling for outlawing bigamy and polygamy. And of course, laws were added when Utah became a state. They had to give up that practice, and they did pass a law against it, but they weren't enforcing it. So there were people that said, we need to have an amendment for this. And there's amendments for prayer, to outlaw abortion, to all these, and some of them sound pretty good, right? But it wasn't until the mid-70s that there was a calls for a balanced budget amendment. Okay, now, balanced budget amendment, if you're a fiscal conservative, sounds pretty good. Who would want to have a balanced budget amendment? But you always have to read the fine print. It's not just something that may sound good, because the first time I heard about it, I said, well, who would be against that? Well, as you read some of the proposed amendments, most of these amendments do call for an unbalanced budget in time of war or national emergency. And I'm understanding that we've been in some state of national emergency for a long time. You know, especially if something happens in another part of the world, national emergency. So, and also, I think as Mark Levine, and we'll talk about him in his book a little bit, in a while, he wants to be able to, yeah, you can have an unbalanced budget if 26 states, or whatever the percentage is, go along with it. And so now you've taken that function of Congress, of this amendment that he proposes goes through, and you've fundamentally changed our structure, you see. So, and I look at it this way, we need a constitutional budget. None of these remedies will actually rein in this out-of-control government. And you know, technically we balance the budget when we borrow money or print more up. So we just go deeper in debt. So the solution isn't a balanced budget amendment, it's a constitutional budget, you see, and that's the thing that a lot of people miss. So, from the 70s to 79, numerous states had called for a convention. And again, I want to reinforce the notion that even if the states apply for a specific purpose and say if it's anything else, everybody goes home, it's like when a plane takes off, you can't get off, the passengers can't get off the plane once it's in the air, you see. The Constitution just says you call for amendment of a convention, period. The purpose is your business. Whatever you ask, you put in that resolution, it makes no difference. So we were actually 2 states away by the mid-80s. What happened was, I think when Reagan got elected, a lot of the people pushing for one decided, hey, we're all set now. We got a good Republican in there. We have no problems anymore. But in '79, in the U.S. Senate has a committee on the Constitution. It's a subcommittee of the judiciary. And they held hearings. And a man named Orrin Hatch, who's still in the Senate, I believe, from Utah, submitted some bills that would control the convention. Now, if Congress will call for one, Congress also has that, what do you call it, the under Article 1, Section 8, necessary and proper clause, that they have to pass laws that are necessary and proper to carry out the duties or powers granted to them in the Constitution. Now, there are some, and I'm of the agreement that Congress really can't have any control over Article 5, because they're actually above Article. Congress is separate. Exactly. But they tried, they had hearings, and they had law professors from all different backgrounds, and almost to a person, they said, you don't want to have this. They used the word runaway. They were, you know, it's fraught with danger, it's pregnant with danger, all these great terms they came up with. And I have a copy of the document, or the report, and it's very hard to find. It's in a few libraries here and there, but just a few days ago, and we are here in mid-March of 2014, I was able to put it up on a PDF file, put it up online. So I'm making it available to tell people that some of these modern-day Constitution Convention, Article 5 people who tell us that only a handful of people had really opposed this back in the 70s, no, this was quite a few people. And so the bills never passed, and but there was a lady that worked for the committee. Her name was Linda Rogers Kingsbury. She's a liberal lady, but she's very concerned. She says, we can't have a convention. We don't want to have a convention. This will be a disaster. We'll lose our Constitution. So she got a lot of groups. American Legion, the NRA, you know anything about that group? Yeah, is that a fringe group that out of the mainstream, right? The Daughters of the American Revolution. She got the Teachers Society, the NEA, and other left-wing, right-wing groups to pass resolutions at their conventions. We have copies of all these resolutions. The NAACP opposed the convention. And they all may have different reasons, but the fact is they were right to oppose it. And by the mid-'80s, again, we were 2 states away, and our organization got involved, and we started telling, we got to rescind these calls. So we were able to get a lot of states to rescind their calls. About from mid-'80s to 2012, we got 13 states to rescind all of their calls for a convention. Now in the mid-'90s, there was another, we refer to these as the con men, or the con men. thought, okay, we're gonna try something else. We're gonna try to have something called a Conference of the States. And they got the Governor Leavitt of Utah to be the front man for this. And they were gonna just get a simple majority of states, and they were gonna have governors and some state officials to meet. And that could have triggered an Article 5 convention. But we were able to derail this pretty quickly, within a few months. That's before the internet was as popular, and all the search engines too. And from there on, there wasn't a lot of movement. We were trying to get people to rescind their states, to rescind their calls. And we'd go to the state houses, visit these politicians, and it seemed to be the last thing they were interested in. It was like they didn't know what it was, and this has nothing to do with us. But it took a lot of work, a lot of educating, a lot of informing, a lot of materials that we published, and we had DVDs. And by 2012, a lot of states had pulled out. But something interesting happened. It was always different groups that have been pushing it. And you'd see one pop up maybe in Ohio, and we'd get our people mobilized and we'd kill it. But in 2011, there was a conference at Harvard University in September. And of course, Dan and I were both there. Well, Dan was on the outside, handing out literature and talking to people. And this was a convention on the on the CONCON. And it took place in September. And if you want to go to their site, conconcon.org, and you see all the people that were there. Now, when I heard about this a few months prior to that, I thought, well, we should have representation there. It was being billed as both. There was only two sides of this. You either want one or you don't want one. You can't have half a CONCON, right? It was both sides would be represented. We're just going to sit there and have a great time and sing Kumbaya and hold hands and have what we have in common and where we disagree. Well, our organization's been on the cutting edge of this issue. They never returned my calls, never returned my emails. So it looked like they really didn't want to have a whole lot of people there to talk against it. They did have at least one, Professor Lawrence Trutt, a liberal professor from Harvard University. And he's also, if you go to that website, you can actually see his presentation. And he does an excellent job refuting in a very polite manner. He's not calling anyone names and making accusations or what have you. Anyway, so he's long, in fact, that document I just mentioned, that 1,300-page document, his writings are in there, why it's a bad idea. I think he used the term fraught with danger or pregnant with danger as a term that he may have used in that article. So anyway, I got there as I was able to get to the meeting as a media for the New American Magazine. So I got media credentials. So I can't be a panelist, but at least I was able to talk to people, interview people, and get a gist of it. It looked like everybody there was pushing for an Article 5. You had groups like Common Cause, which is a left-wing advocacy group funded by the Rockefeller brothers back in the early 70s. You had the Coffee Party. There was a lady, a very professional-looking young lady, who was with the Occupy Wall Street. She's out of New Jersey. Well, what are they doing here at this event? And it was co-sponsored by the Tea Party Patriots, a man named Mark Meckler. Also the Goldwater Institute, named after the late Barry Goldwater, who, by the way, opposed an Article 5 convention. I think his son's involved, and he's very much in favor of one. So you had the Cato Institute also. It's a libertarian-type think tank, all pushing for a CONCON. And I can understand working with people to stop one who have different backgrounds, but when you work with people that you disagree with for a convention, what were they trying to do? Yeah. So, and then now Mark Meckler, who's head of this, he's resigned from Tea Party Patriots. He formed something called Convention of the States, which was about a year ago, for the sole purpose of pushing an Article 5 convention. And it's interesting that at the conference that they co-sponsored and must have co-paid. It's a lot of money for one of these conferences at Harvard. He came out and said, "Yeah, I'm not really sure. I don't like what Professor Lessig of Harvard. I don't really like their amendment. They have an amendment. They want to do away with the notion of corporate personhood. They didn't like that decision that came out with Citizens United. That free people can donate money to an organization. They can expose voting records independent of the campaign. I guess they don't like that if their people are being the ones that are being exposed or what have you. That works both ways too, So I remember down on Cape Cod, the man that was running for Congress about 4 years ago, the former policeman.
Perry?
Perry. And there was some information about his when he was a policeman, and there was this group that was putting out stuff about that. It raised $1 million. Well, that may have made the difference. No, those folks go out of business, and with this amendment being passed, those guys would go out of business too, so it works both ways. Anyway, but anyway, he left there saying, yeah, but not really, because we actually interviewed him. I didn't get a chance to, but my colleague did. And, well, I don't know, if you're gonna invest lots of money and come to all the way from California to Boston, you think you already made your mind up, you know? And now he's got this group, Conference of the States, and he has Mike Farris of the Homeschool Legal Defense Association. Now, he's sort of independent, so the homeschool group itself is not pushing this. And they've also, and you've got the group called Wolfpack on the other side of the spectrum. The Wolfpack, if you go to their website, wolf.pack.org, it is, not only do they want this corporate personhood issue, but they also want to have the public funding of elections. And that means that government will determine the viable candidates. That to me is very dangerous. They want to talk, they use the word democracy a lot. Well, they haven't read it.
Sounds like Nazi Germany.
Well, let me tell you, the guy who was ahead of Wolfpack, yeah, the submarine, yeah, the U-boats, his name is, I'm not pronouncing his name right, it's Cenk, C-E-N-K, Erger, I think. He used to be a neoconservative, and he had some conservative credentials as a younger man. He's from Turkey, born in Turkey, but moved here as a young boy, so U.S. citizen. And, but he's become a hardcore progressive over the last few years. And he is funded by George Soros. He has this entity called the Young Turks, you see. And he's the one that's the founder of Wolfpack. He was also at this Harvard conference. There was another very interesting lady at this Harvard conference, Professor Meg Penrose. Meg Penrose, you thought, well, another law professor, what's the big deal? Well, she's in Hartford, she's in Connecticut, UConn, University of Connecticut, put on a forum, basically how to trash the Second Amendment. And she's speaking at this forum, this was fall of 2013. And she's saying that the Constitution is an absolute, that we don't wear the clothes we wore back then, so why should we have their Constitution? And she loves the Constitution, but we need a rewrite. It's time to rewrite it, and we need to have an Article 5 convention to rewrite it. So all these people meet in Harvard, different political stripes are all pushing for the same thing. And now here in Massachusetts, we have two resolutions that are pending. In the House, it's House 3190, and in the Senate, it's 1727. And if you contact me, I'll be able to get you all the information on this. And I would thank Dan for bringing them, because I didn't get them today, I didn't have them with me. But they're not quite identical, but they're calling for the same thing, sponsored by the Wolfpack people. They testified along with Larry Lessig, Harvard professor, in July of last year, July of 2013. Somehow we never got the word, so we never showed up because we didn't even know this was being proposed. And so we think these will die in committee, but we can't be certain about that. And Massachusetts still has about 4 old calls, so we want to get those calls off the books too. Now, the Conference of the States people spent a lot of time going after the John Birch Society, because we've been, so like I said, on the cutting edge. And I think people of well-intentioned people who may disagree can do so without resorting to name calling. But I guess that's not the way they'd like to do it. Mark Meckler wrote an article about Phyllis Schlafly. Now, Phyllis Schlafly had the Equal Forum. She was been working on the subject for many years, since the early 80s, even before the JBS got involved, possibly. And she was friendly with Warren Burger. They may have disagreed on a lot of things. He was a Supreme Court justice who supported abortion, unfortunately. But he was against an Article 5. So he wrote a letter to Phyllis saying why it's a bad idea. So here's Mark Meckler saying all she has in her defense is this letter from the 70s, that's actually from the 80s, and she's feebly clutching this letter. Well, when I presented this, this 1,300-page report, I think I kind of refuted that notion. And Mike Farris, and I'm a homeschooling parent. I have a lot in common with homeschoolers. He said that John Birch Society is in any other constitution because we oppose this, and also that we are evil. Now that to me is bearing false witness here, You're supposed to be a Christian, man. You don't do that kind of thing. He never got involved with this issue. He was nowhere to be found, a few years ago, like Mark Meckler. Where were they, 10 years ago, 5 years ago? Where were they opposing Agenda 21? It didn't affect them, they didn't touch it, right? It didn't affect homeschooling directly, you don't touch it. All of a sudden, we have to have this convention or all is lost. Right? And they accuse us of scaring people. Oh, you're afraid of a convention. Oh, we're very concerned about one, you better believe it. And they say, if we don't have one, all is lost. Well, that's not the case. All isn't lost. It's a long way to go. And their major premise is that a bunch of new amendments will somehow save our country. And they use the word republic lately. It's always nice when they say republic, because a lot of people don't even know the difference between a democracy and a republic.
Exactly.
So, I had one guy from Massachusetts, he's a member of this Conference of the States group. He's very online, he's calling me a liar. It's a pretty strong word. Let's have a debate. Oh, he doesn't want a debate, but he can call me a liar on cyberspace. But they're convinced that you can add amendments. I think there's over 100 amendments out there, different. Some of them deal with radically restructuring our country, our form of government. Some of them deal with repealing the 17th Amendment. I can go along with that, but not through an Article 5 convention. Some of them want to take the Second Amendment away. Some of them are calling for to abolish electoral college. And if you read Mark Levin, and I have an article that I want to show people, and that's available. You can go to thenewamerican.com website and get it from the website, or I have it in a PDF format, and call me or you can email me and get your hard copy. Back in August of last year, August of 2013, he came out with a book called The Liberty Amendments. He's a talk show host. I refer to him as a neoconservative.
Mark Levin.
Mark Levin, yeah. And he's on, I think he's on in the Boston area on WRKO. And I listen to him sometimes, and a lot I agree with him. It's interesting too, because he's another guy that gets very nasty if you don't agree with him. Now, when he bashes Obama, everyone, oh, he loves it. But when he bashes fellow patriots, you know, then it's a little different. And he's been bashing the John Birch Society because we don't go along with this Article 5. And the book's a pretty good seller too. So this book, he's got about 11 amendments, and most of these will radically transform our republic. Now,
It'd be saying the day before the show. Yeah.
yeah. And the thing is, and he probably thinks these are great, right?
Yeah.
These are great things. And the average person looking at that will say, someone who might know a little bit of the Constitution, but most people are constitutionally literate. You know that. That's why you do the show, to help people understand that.
Yeah.
You know, when I testify in these hearings, and I'll be talking about it later on today, for the next. In fact, Dan and I, we did from January to just a few weeks ago, we did press releases on my site, news conferences at state capitals in New England. So we had six states in the last 6 weeks or so. And one of the things we will discuss is that these people, you talk to the average person, they don't know what Article 5 is about anyway. Mm-hmm. So you have to educate legislators what this even entails. And usually, you know, the first view they hear is the one they latch onto. Until we have, hey, it takes a long time to convince people once they caught into an idea, you know. So anyway, I was going to mention. So I was talking about Levin also gets. But he was saying, and I don't catch him too often, but he was saying that his favorite. He said the most brilliant legal mind of his time was the late Robert Bork, Judge Robert Bork. Well, wouldn't you know, Robert Bork opposed an Article 5 convention. And ironic, he was at that group called CPAC, which is this conference every year that's held down in the D.C. area. And all of the Republican wannabes show up, and there's different groups that show up. Well, Levin gets an award from Citizens United. I got a picture, I'll show that picture in my presentation. I'm sure and I went to the Citizens United Facebook page, and I said, I wonder if you folks know that the left-wing side of the Article 5 people want to put you out of business. And Levin's pushing the same thing that they're pushing. I wonder if they know that. Mike Farris, big homeschool legal defense guy, he also opposes, rightly so, Common Core, because Common Core does affect homeschoolers directly, as well as everybody else. And the National Council of Governors, State Governors, the National Governors NGA, National Governors Association, holds the copyright for Common Core, and also want an Article 5. So they're going to have it. If they have, God forbid, if we have one, it'd be interesting to see. We know who's going to run the day. It's not going to be the Constitution. Mike Farris's amendment is called the Parental Rights Amendment. The Constitution doesn't say anything about parental rights. That means parents have the rights. I don't need an amendment to tell me I have parental rights. So on that amendment, if it's passed, and to read it, it sounds, well, what's wrong with that? You've just given the power over the family to the federal government. Why would you want to do that? You see, their mindset is, and he's an attorney.
Though in lots of ways, we're allowed them to do it anyways.
Well, they are. Oh, there's no question about that. Oh, yeah, there's no question about that. But now we've made it, now we get it in writing.
Yeah, we get it in writing.
Now it's in black and white. And their notion is that the Supreme Court is the final say in the Constitution.
That's right.
And I know he's our Edwin Vieira scholar. He said Edwin Vieira says the Constitution isn't what the Supreme Court says it is.
That's right.
It's what it says it is.
That's right.
Supreme Courts have made bad decisions. In some cases, they've overruled, and then overruled that, again. So, that Second Amendment isn't whatever the Supreme Court says, it's what the Constitution says. And if you don't know, go to the original intent. The founders could tell you very easily. We know exactly what they
You go
meant
back
by
and see
it.
what they said. I mean,
Exactly.
you go back and see what Jefferson said in Madison versus Mulberry.
Yeah.
Because they always use that one as the basis of saying, well, the Supreme Court can do all this and they can
Yeah.
say all that. But yet, if you look at it, when it came down to the fact that when Supreme Court marshal said, yeah, you have to make Mulberry and the rest of them judges because they were appointed.
Pointed, right.
But they never went in front of the Congress and everything to appoint them. Adams made them,
Yeah,
appointed them.
before you.
They never got the official point. And Jefferson just says, see what they say, you don't belong here. You're
Yeah.
the third article of the government. Get back to where you belong.
That's right.
Abraham Lincoln did the same thing when they told him about when he was going to free the slaves.
Yeah.
Although we had the Civil War, it didn't matter anyways. But Jefferson said the same thing because the Supreme Court said, oh no, because the South was very strong in the legislature back then. And the Supreme Court agreed with the South.
Mhm.
It said, no, this is a slave nation, we will have slavery. And Lincoln said, thank God it was only the Supreme Court that said, they got no standing here. Get back to where you belong.
Yeah, the Article 3 of the Constitution that deals with Supreme Court. Article 3, Section 2 says that Congress can limit the Supreme Court's appellate jurisdiction. So if they do step out of
And they will
bounds,
sit upon good behavior.
and they can be impeached, or they can be for good behavior, yeah. And when they're looking at this European law as a basis for the decisions, that to me is bad behavior. Now, when I give a presentation at these state
Well,
houses,
just quickly, you go back and as I always say, you go back and look what they did. When a judge did have bad behavior, what was bad behavior? Best way to find out is look what they did, who wrote it.
that's right,
And they fired judges for getting drunk at home because it wasn't good behavior.
that's right.
They actually did. They fired people for yelling at somebody in the court because it wasn't good behavior.
Good behavior.
I mean, you go look at what John Wilson had to say. One of the first Supreme Court judges. He wrote the books on American law today in colleges and everything, and because he said, he says, we continue down the road that we're doing right now because we had become a nation ourselves, but we were still teaching public school the way England did. So they were afraid they were going to raise a bunch of kids. They're all of a sudden going to say, what's wrong with England? We'd like to have them back.
Oh, yeah,
You'll
yeah,
learn it how.
yeah.
We still use the English way of learning. And he said, we've got to do away with this English law that we're still practicing. And he wrote the first 4 books of law from Massachusetts. He sat on the Supreme Court. In fact, he taught it. It wasn't a full-time job at the Supreme Court back then.
Really? Oh, that's right too, yeah.
He actually taught it.
Yeah. Very, very interesting. So when we give our news press conferences, Dan gets into the enforcement aspect of the. Don't amend, but enforce.
Right.
So I can throw it over to Dan for a little bit because I've been
Sure.
monopolizing the show.
Yeah.
So
That's what it's all about. We're gonna get, before we have you on here. Dan, what do you got to say for yourself?
Well, the major project I'm working on is restoration of constitutional security, necessary restoration of constitutional security, constitutional enforcement. So, Hal, on this Article 5 movement to amend the Constitution in a convention, would be the first one since 1787. Hal and I, we found common ground, and I was fortunate that I found this commentary written by Dr. Vieira, who we've mentioned before.
and he's the author of this book, Constitutional Homeland Security.
Yeah.
That we recommend.
Right. And
A Harvard graduate too.
4 degrees, yes.
4 degrees in a thermometer.
So, and I'm going to get into those specifics of the enforcement and the need for no amendment. But first I want to just say flat out, regarding Mark Levin and these other high-profile people that are promoting a constitutional convention or a conference of the states, whatever they're calling it, it's the same thing. It's an Article 5. to amend the Constitution, I'll say flat out, they're all off point. And they're ignoring the existing Constitution and Bill of Rights. They're ignoring the fact that the problem is not the Constitution's design and purpose. Of government, the design and purpose of government. In fact, the problems are the improper governmental and money systems operations, and current failure to revitalize by state legislators, whose responsibility it would be, to revitalize constitutional security and enforcement by either passing or revising an existing statute, one statute in each state. So they can either promote a statute, state statute, or they can promote this full-blown